Hi, I'm Shashank Bhargava, and you're listening to Three Things, the Indian Express news show. For several decades now, the Gyanvapi Mosque in Varanasi, which stands adjacent to the historic Kashi Vishwanath temple, has been at the center of multiple legal disputes between the Hindu and Muslim devotees. For context, the mosque was built in 1669 during the reign of the Mughal Emperor Aurangzeb, and the Hindu petitioners have claimed that he ordered the demolition of the pre-existing Vishweshwar temple at the site, replacing it with the mosque. And this is the reason that Hindu and Muslim petitioners for years now have been at odds over who has the right to worship on the premises. While the Muslim side argues that the mosque was built on Waqf premises, the Hindu side argues that it was built on the site of an older temple. The decades-old litigation around the mosque gained momentum in 2021 when 5 Hindu women sought the right to worship Ma Shringar Gauri on the outer wall of the mosque complex. Later, in May 2022, when a shivling was found during a videographic survey, the Allahabad High Court passed an order directing the Archaeological Survey of India to conduct a scientific survey of the premises. Now, the final report of this survey was handed over to both sides last week. And this report reveals that a Hindu temple existed prior to the construction of the existing structure. To tell us about this report, Indian Express's Asad Rehman joins us. Asad, can you begin by telling us when this report first came to light and just how detailed it is?
So this report was submitted last month in the district court, but initially it was not made available to the parties in the case, the litigants in the case. But recently the court ordered that copies of this report will be made available to the parties. So on Thursday, this report was handed over to all the litigants, which is the Hindu side and the Muslim side. And after that, it became public because the litigants and their lawyers have shared the report with journalists and have shared the findings with journalists. And we have also procured a copy of the full report. The report is more than 800 pages. It is divided in 4 volumes. It is very extensive and very detailed. There is a index page with all the contents and how the ASI went about the survey, how they conducted it, what methods were used during the survey to ascertain the characteristics of the mosque and other aspects of this building that is there in Varanasi, the Gyanvapi Mosque.
And Asad, this survey was done to ascertain whether the Gyanvapi Mosque was constructed over a pre-existing Hindu temple or not. So what does this survey says in its conclusion?
So the ASI report says that a pre-existing temple was there at that site, which is plot number 9130 in Varanasi, next to Kashi Vishwanath temple, and that this pre-existing structure appears to have been destroyed in the 17th century during the reign of Aurangzeb, and part of it was modified and reused in the existing structure, which is the Gyanvapi Mosque. Then the report also says that, and now I'm quoting, that there are in fact inscriptions on the stones of the pre-existing Hindu temples which have been reused during the construction repair of the existing structure. They include inscriptions in Devanagari, Grantha, Telugu and Kannada script. Reuse of earlier inscriptions in the structure suggests that the earlier structures were destroyed and their parts were reused in the construction repair of the existing structure. This is what the report reads exactly. Then the report also says that the 3 names of deities such as Janardhan, Rudra, Umeswara are found in these inscriptions. And there are several terms which have also been noted down in the report that point to this conclusion that there existed a temple at the site before this mosque was constructed.
And can you tell us what the report says about the old temple that existed there?
So the report says that the pre-existing temple had a central chamber which was, now I'm quoting from the report, tastefully decorated with carvings of animals and birds, pillars with lotus medallion and flower bird chains, a large decorated entrance gateway on the wall of one of the chambers. And this is all part of the report, and that these formed a part of a large Hindu temple that existed at the site in Varanasi where the Gyanvapi Mosque now stands. So this is all findings from the report. We've read the report, and all this is part of the report that was submitted to the district court last month.
And the report also goes into the kind of stone structures that were present there in the temple, right? So talk about those a bit.
Yes, the report says that a total of 55 stone sculptures were found in the mosque complex, and that 15 of these stone sculptures, as per the report, are Shivlings. 3 of them are sculptures of Vishnu, 3 are of Ganesh, 2 of Nandi, and 2 of Krishna, and 5 of Hanuman. These are all Hindu deities, and the ASI has specifically named these deities in their report and has said that these deities, their sculptures were found in the mosque complex. And these are things that have helped the ASI reach the conclusion in their report that a pre-existing temple was destroyed and a mosque was built there during Aurangzeb's reign.
And Asad, after the report has come out, what have been the reactions from both the litigants in the case?
So the Muslim side, which is the Anjuman Intizamiya Masajid Committee, which handles the Gyanvapi Mosque, and is saying that they are going to file objections to this report, and that this report is not the final word, and that they are going to object to it in the district court. The next hearing is on February 6th, which is in a week's time. So they are going to file their objections either on that date or at a later date. But the Masjid Committee is saying that they are going to challenge this report in the court and its findings as well. And now what aspect they challenge will be found out once they file their objections in the district court in Varanasi. The Hindu side, on the other hand, is quite convinced that this report is going to be the clinching piece of evidence that they wanted, even though an ASI report, whether it will be considered as evidence or not, is up to the court. And their claim that there existed a Hindu temple has been further strengthened by this report, because it says what the Hindu side was saying, that a temple existed there and that it was destroyed to build this Gyanvapi Mosque.
And considering how contentious this issue is, and since we just saw the consecration of the Ram Mandir, what would you say are the political implications of this case?
So far, no political party has reacted on this case and the findings of the ASI report. Neither the opposition nor the BJP in UP has spoken about this case so far. But a few months ago, Chief Minister Yogi Adityanath of Uttar Pradesh had spoken about the Gyanvapi Mosque, and he had said that it should not be called a mosque anymore, and that the matter is sub judice in court and they will respect and follow whatever the court says in this case. So whether this issue is going to become political or not is something that we'll have to wait to see. Because for now, all political parties have stayed away from this issue and have not spoken anything on this issue. And in the days to come, whether this becomes part of the political discourse in Uttar Pradesh and at the national level is something we'll have to wait and watch.
Now, when talking about this survey, it's important for us to further consider the kind of impact it will have on this entire case and the extent to which it will be relied on. To talk about all this and more, we now speak to Indian Express's Apurva Vishwanath, who reports on law for the paper. Apurva, based on what we have found out from this ASI report, how do we see it impacting this case?
So it is significant that the ASI report says that there was a Hindu structure, a Hindu temple specifically, underneath the Gyanvapi Mosque right now. And parts of the temple structures have been remodeled or used in the construction of the mosque itself. But if you ask what is the relevance for this case, as of now, it isn't that relevant, because what we have in front of us is, or the legal test that the courts have to decide is whether this religious structure, the character of it on 15th August 1947. So what it was centuries ago doesn't really matter to the legal case as of now. Of course, that could change.
So basically what they're trying to find out is whether this structure was being used as a temple, whether Hindu devotees were worshipping there till 15th August 1947.
Yes, the timeline is 15th August 1947 for the legal case, because that is the cutoff date that the Places of Worship Act 1991 introduces. So on the date of independence, if something was a mosque, it would continue to remain a mosque. If something were a temple, it would continue to remain a temple. So the factual determination for the court to make is what was the nature of that place as of date of independence. What it was before that doesn't matter materially to the case itself.
And you mentioned that this could change. What exactly would bring about that change?
So, like we've discussed about the Places of Worship Act, it was introduced in the wake of the Ram Janmabhoomi movement. The idea behind this legislation was to put a stop to this political sloganeering that Ayodhya bas jhanki hai, Kashi Mathura baki hai. To ensure that the politics around the Ayodhya movement don't repeat itself, the artificial cutoff date that was introduced in this law is the date of independence. So after Ayodhya, because by then the litigation in Ayodhya was already pending. So except for that, the legislation effectively bars any litigation looking into the title of any other place of worship. So you cannot now go into Kashi and Mathura or any other religious structure in the country. That was the idea behind this legislation. But that legislation is under challenge before the Supreme Court. There was some indication that the challenge might be referred to a larger bench, but the government is yet to respond. In the meantime, even if legislatively there is a review of this law, because the BJP has, since the inception of the law, not been in favor of such a legislation. Uma Bharti famously in Parliament attacked the then Congress government for bringing about such a legislation itself. So in case there is a change in the status of the Places of Worship Act, then of course things would change.
And Apurva, when we talk about the ASI report, could the validity of that be challenged in the courts?
Absolutely. The ASI report at best is a form of expert evidence that the court will have to use to determine facts, right? It will not be taken as gospel truth in court. How a civil court works is that now that there is a report, from the authors of the report, a lot of them will be asked to depose before the court. So these testimonies will be taken and they will be cross-examined. And that is a factual matrix with which the court will have to work. And that's what we've seen in the Ayodhya case as well. So in 2003, the ASI had submitted a report, which the Hindu side often quoted in their favor, that there was a Hindu structure underneath the Babri Masjid. So eventually, if you look at the 2019 Supreme Court judgment in the Ram Janmabhoomi case, the court doesn't rely upon the ASI report because the court feels that the report doesn't show for sure that a Hindu structure was demolished, razed down to build a mosque. The dating of that Hindu structure is for the 12th century, whereas the Babri Masjid, the origins of it is somewhere in the 16th century. So what happened in that intervening period is something that the ASI hasn't been able to ascertain in the report itself. So that's the detail to which the court goes in making that determination. Of course, eventually the court did rule in the Ayodhya case as a matter of faith, going beyond the evidence presented, going beyond, a lot of these arguments. But at the core of it, the ASI report was not accepted in its totality.
Right, and there are other examples of this from the Ayodhya case. Could you maybe cite another one for our listeners?
So if you look at the Allahabad High Court trial that happened in the Ayodhya case, we didn't have a lower court intervention there. It straight away went to the Allahabad High Court. That judgment came in 2010. So that report, there are testimonies by archaeologists, epigraphists, cartographists, historians who all come to court and testify. A line in the ASI report says that there is use of lime surkhi in the underlying structure that they claim to have found. Here, the Muslim side argued that lime surkhi is very commonly used in Islamic architecture. And they had plenty of examples from history and monuments which are still there to show that lime surkhi is essentially an Islamic use, which basically meant that underneath the Babri, there were older mosques. That's the argument the Muslim side was making. But the Hindu side brought evidence of basically testimonies of historians to show that lime surkhi was used as early as in the 3rd century during the Kushana period and also in Takshashila in Pakistan. So it could also be used in Hindu structures, right? So there is a fact finding or an opinion of the ASI. How that should be interpreted to come to the conclusion that something is a fact is the court's remit. That is what the court will have to now do.
And Apurva, where does the case go from here? What will the courts have to look at now?
So as far as where we go from here, of course, in the trial court itself at the district level in Varanasi, the civil judge will now have to hear the challenge to the ASI report. Testimonies have to be brought in. A lot of documentation will have to be checked. So that trial will go on. But there is a preliminary objection or an appeal that the Muslim side has filed before the Supreme Court, which is on the maintainability of the plea itself. The argument that senior advocate Huzaifa Ahmadi had made in the Supreme Court is that as long as the 1991 Act exists, which it does today, there cannot be a suit which can be admitted by courts challenging the title of any place of worship. Here, the Varanasi court has, of course, dismissed this claim, but that is the appeal that is essentially pending before the Supreme Court. The Supreme Court is yet to decide that. What we've seen so far is the Chief Justice of India, when he sat in a combination of 3 judges, made an oral observation that, at this stage, you can still have a trial because a trial court can perhaps look into the factual matrix as to what was the religious structure on 15th August 1947. But that's just an oral observation. In legal terms, it doesn't carry much weight. So we've been working on the assumption that such an exemption to the maintainability can be made. But that is something that the Supreme Court will have to hear final arguments and decide conclusively, basically deliver an order, right? That order of the court will then speak for itself. So till that happens, the maintainability of this suit is in question.
So basically the Supreme Court will have to determine whether this case itself is valid, whether we can hear the suit in the first place, because it is about changing the religious character of that structure, which according to the Places of Worship Act, we are not allowed to do.
Absolutely. So that's something that the court will have to determine. If it accepts the argument made by the Muslim side that such a plea cannot even be filed in the first place because the 1991 Act bars it, then, the ASI report or this whole thing is a very different equation. But politically, of course, it is a very crucial litigation. And it is important to note that this ASI report has been made public just days after the inauguration of the temple in Ayodhya. And we've been hearing all along that once Ayodhya is done, the focus or the political focus will shift to other places, including Kashi and Mathura, where there is already litigation that is happening.
And Apurva, when we talk about the maintainability of this plea, the Muslim side argues that there are actually 3 laws that challenge it. One of them, of course, is the Places of Worship Act that we discussed. What are the other 2?
Yes. So the second aspect is the Muslim side has argued that it goes against the Waqf Act as well. For the Muslim side, the contention is that the mosque has been built on Waqf property, and this is established by the publication in the Varanasi Gazette that the land on which the Gyanvapi Mosque is built belongs to Waqf. So there's a registration number and a declaration that this belongs to the Waqf property in the official gazette. The third law that the Muslim side has argued would hit is the Kashi Vishwanath Temple Act, which is a 1983 legislation which actually demarcates what land belongs to the deity Adi Vishweshwar and how the temple is managed and run. So the Muslim side says this legislation clearly takes care of what is temple land and what isn't. So the civil suit is barred by this as well. However, the district judge last year ruled that all these 3 claims were not accepted and that the civil suit will have to be heard on merits. So these 3 claims that the Muslim side made will now be looked at the evidentiary stage. The court will actually look into documents and evidence that it deems fit to come to these conclusions.
You were listening to 3 Things by The Indian Express. Today's show was edited and mixed by Suresh Pawar and was produced by Niharika Nanda and me, Shashank Bhargava. If you liked the show, then do subscribe to us wherever you get your podcast. You can also recommend the show to someone you think will like it, share it with a friend or someone in your family. It's the best way to get to know about us. You can also tweet us at Express Audio and write to us at podcast@indianexpress.com.